Thank you very much, Professor. We'll now move to, having concluded outcome one, we'll now move to sport and recreation, finally. So thank you to everyone who's participated in this fun day so far. So, yeah, it's going to be better.
So, are we going to ASADA first? How are we doing this?
Well,
so we got a few different bodies.
Yes. Well, at the beginning of this session, I was given to understand that Mr. McDevitt has a statement
Yes,
he would like
that's
to make.
assuming we're starting with ASADA.
Yeah. Well, look, let's go that way. I think, well, Senator Farrell and Senator Brown, we largely in your hands. Do you want to start with ASADA? Okay. Well, Mr. McDevitt, we understand this may be your last time
That's right.
with us,
Yep.
and I'm sure you're very sad. Would you like to make an opening statement?
Thank you, Mr. Chair. Ben McDevitt, CEO of ASADA, and thank you for allowing me to make a short statement. I expect this will be my last appearance before this committee as CEO of ASADA. As you may be aware, my contract expires in early May and I've declined the opportunity to renew it. That said, given the calls for a Senate inquiry in recent days, I'd like to make it crystal clear right now that should one be held, I'd make myself readily available. Over the past couple of decades, I've had many opportunities to appear before various committees within this building. On all occasions, I've done my utmost to furnish these important committees with the most accurate and fulsome responses. I take the evidence that I give to these committees very seriously. Since my last appearance before this committee, I've received correspondence from you, Mr. Chair, in which you advised me that the committee has carefully considered allegations you received from Mr. Bruce Francis and Mr. Allan to the effect that I may have provided this committee with false and misleading evidence. I note you state in your letter to me that this committee is satisfied after considering the allegations that in fact I have not provided the committee with false or misleading evidence, and I thank the committee for its deliberation and decision on these matters. My job as the anti-doping regulator for the past 3 years has been, amongst other things, to pursue allegations of possible breaches of Australia's anti-doping rules. There are many unique features of our anti-doping framework, primarily designed to ensure that as matters progress, there are opportunities for athletes to be legally represented, to detail their case, to outline any defences to allegations, and to appeal decisions made at various levels of arbitration. Mr. Chair, the critical word here is arbitration. At the risk of oversimplification, sports law is essentially based on a process of arbitration and contracts. It's also important to emphasise that Australia's response to doping in sport is not governed by the criminal law. Instead, it's largely enabled through contractual agreements between the parties, and at its heart is the globally accepted premise of an athlete's personal responsibility for what goes into their body. It includes a strictly defined process for the adjudication of alleged breaches, which is entered into by athletes when they agree to sign a contract to play their chosen sport. So, for example, when Essendon players signed their contracts, they agreed to a framework of arbitration which allowed for anti-doping allegations to be heard in the first instance by the AFL Anti-Doping Tribunal, and then for there to be avenues for various parties to appeal findings to higher bodies, including the AFL Anti-Doping Appeals Tribunal and/or to the Court of Arbitration for Sport. So claims that players in this instance were tried twice for the same offence are patently false. What happened here is that the parties involved followed to the letter the agreed contractual appeal mechanisms. The arbitration procedure that all players had agreed to contained avenues for appeals by WADA to the Court of Arbitration for Sport against decisions of the AFL's own tribunals. This appeal opportunity is common to almost every contract signed by an Australian sports person, and in fact most appeals to the Court of Arbitration for Sport are actually initiated by athletes themselves. The fact that an appeal to the Court of Arbitration for Sport was lodged in the Essendon matter was certainly not a unique event in Australian sports administration, and certainly not a denial of the players' rights. This is just one example of the chasm which seems to exist between those infinitely versed in the administration of sports law, such as the numerous highly experienced teams of lawyers and barristers who represented Essendon and the players throughout these matters, and the understanding of occasionally confused onlookers who are generally more familiar with the criminal law processes. One stark similarity between the criminal and anti-doping regimes is that under both there are multiple opportunities for both the merits of a particular case and the processes applied in advancing the case to be subjected to extensive scrutiny by external authorities. We are all acutely aware that in the Essendon case, both the merits of the evidence itself against the players and the manner by which some of that evidence was obtained, i.e. via a joint investigation, have been canvassed thoroughly and exhaustively. Aspects of this case have been forensically examined by bodies including but not limited to the Independent Anti-Doping Rule Violation Panel, the AFL Anti-Doping Tribunal, the Victorian Supreme Court, the Federal Court of Australia by both single judge and then via full bench, the Court of Arbitration for Sport, and even the Swiss Federal Court. I make this point given the recent call to arms by some for a Senate inquiry into some as yet unidentified aspects of the Essendon case. One plain fact I would make is the obvious point that a Senate inquiry cannot have the effect of setting aside the rulings of either the findings of lawfulness of ASADA's actions by the full bench of the Federal Court, nor of the findings of doping violations against Essendon players by the Court of Arbitration for Sport. A second plain fact I make is that so far as anti-doping matters can be litigated in this country, either on merit or process, the Essendon matters have been finalised fully. Should members of this committee and others in this place determine that some sort of additional inquiry is necessary for some reason, I restate my willingness to participate as required. I also make the point here that I stand by every decision I have made as CEO of ASADA since my appointment in May of 2014. In closing, I remain firmly of the view that those in our community who accept that doping is a real threat to sport in our country also can see that ASADA is not the enemy and that the fight against doping is not a fight against sport. Thank you, Mr. Chair, and sorry for taking so long, but I needed to put a couple of things on record given some of the recent commentary.
And